Hello, this is Will Fontenot with Fontenot Spevak, and today we're going to talk about attorney fees in a divorce. A question I get very frequently in my cases is, can I make my spouse pay my attorney fees? And the response to this question is actually very complicated, which is what we're going to get into here in a minute. But I would say that in most cases, the other party does not pay the attorney fees for the other spouse. But I think this has more to do with the fact that most of these cases end up getting settled rather than go to court. If you do go to trial and you'd like to make an argument that the other side should have to pay your attorney fees, then we're going to talk about how we're going to, how you would argue that and what the court is going to use to analyze that, because that is what happened in this case. This is the Dahl v. Dahl case. 2015 Utah 79, and this is a Supreme Court case originating out of the 4th District with James Taylor. Judge James Taylor. The attorney for the wife in this case was Steve S. Christensen, and the reason why I've highlighted his name here is going to be apparent here later on in the decision when you see what the court was analyzing here. Okay, so we're going to jump to page 60. This is a 79-page opinion. There were numerous issues raised on appeal in this case. Very complicated case. It wasn't that complicated of a case, but it was made complicated by some things that happened in the case. And then, so the opinion was lengthy and had to deal with a lot of different issues. But we're just going to talk about attorney fees for this video. Okay, let's go to the general rule that a court is going to look at to determine if attorney fees are awardable here. In Utah, attorney fees are awardable only if authorized by statute or by contract. That's just the general rule that applies in every single case. But in divorce cases, we use section 30-3-3-1 of the Utah Code, which authorizes courts to award attorney fees and costs in divorce cases if doing so would enable the other party to prosecute or defend the action. Such an award must be based on evidence of the receiving spouse's financial need, the payor spouse's ability to pay, and the reasonableness of the requested fees. And we'll talk about a little bit more about what the specific factors are that a court's going to use. But that's just the general rule. It goes to the recipient spouse's need, the payor spouse's ability to pay, and then the reasonableness of the fees. Now, in this Dahl case, the district court did not award attorney fees to Ms. Dahl. And the Supreme Court found that the trial court did not abuse its discretion when it refused to award those things. And there were two main reasons for that. So keep in mind, Ms. Dahl attorneys submitted a claim for $2 million, over $2 million in attorney fees, litigation costs, and interest charges through the trial. The district court denied Ms. Dahl's request, finding that Ms. Dahl, through her counsel, had failed to present evidence of her financial need and because the fees and costs claimed by Ms. Dahl's attorney were unreasonable. $2 million for a divorce case and fees. Definitely unreasonable, but we're going to talk about why it is. This is one of my favorite cases just because the Supreme Court, I think, was just so unimpressed with the attorney for the wife. All right, we already read that part. Okay. The court found as a factual matter that Ms. Dahl had adopted a consistent trial strategy wherein she declined to provide competent and complete evidence of her financial need. Second, the court found that the fees claimed by Ms. Dahl's attorneys were unreasonable. Ms. Dahl presented no credible testimony to establish her current financial need. In fact, the district court instructed Ms. Dahl's counsel on no less than 5 occasions to provide a financial declaration that would satisfy the court, but Ms. Dahl failed to do so. Ms. Dahl's counsel confirmed that no financial declaration would be presented during trial and that he intended to rely upon financial information presented in 2007. So this is a 2015 case, but I've done videos before on how important it is to make sure that your financial declaration is correct, and that's something that's very important for an alimony claim. But it can also be very important for an attorney fee claim as well, which is what happened here. The idea that an attorney would not comply with the requirement for a financial declaration, we don't know if that was just the client's obstinance or just the attorney's failure. We don't really know, but ultimately, the choice to not provide a financial declaration is fatal to a claim like this. So always do your financial declaration. Make sure your attorney is submitting the financial declaration. And the financial declaration needs to be done properly. It needs to be accurate, but it needs to show that you have a need if you're going to be making a claim for attorney fees or for alimony. All right. The district court also found Ms. Dahl's claim for more than $2.1 million in attorney fees and costs was unreasonable. A court may consider, among other factors, the difficulty of the litigation, the efficiency of the attorneys in presenting the case, the reasonableness of the number of hours spent on the case, the fee customarily charged in the locality for similar services, the amount involved in the case, and the result attained, and the expertise and experience of the attorneys involved. So this is one thing that if you're briefing up this issue, you're going to want to bring up these aspects like the difficulty of the litigation, the efficiency of the attorneys in presenting the case, the reasonableness of the number of hours spent on the case, the fee customarily charged in the locality for similar services, the amount involved in the case, and the result attained. These are all things that are going to factor into whether the attorney fee claim is reasonable. And this is from Cabrera v. Cottrell. There is a misconception among attorneys, even attorneys who have been practicing for a while, that the test for whether you are entitled to attorney fees is whether you substantially prevail in your case. And that's not really what the statute says. The statute talks about, again, need, ability to pay, and then reasonableness. But one way you can argue that the attorney fees that were incurred by the other party are not reasonable is by going through these factors that I've highlighted here. Okay. So what happened when the court actually did apply the reasonableness test to the attorney fee claim for Ms. Dahl in this case? Let's just read this. As for Mr. Christensen and his firm, the district court found that the hours claimed were unreasonably large. For example, the firm billed 2,981 hours in the 10 months from January through October 2009. Mr. Christensen requested hundreds of thousands of dollars in fees related to discovery of financial matters, but the court found, based on Mr. Christensen's noncompliance with the discovery orders and general lack of preparation for trial, that the discovery was not carefully managed or focused, and that the extremely high fees related to the process were not warranted. Additionally, the court found that Mr. Christensen pursued a strategy involving the aggressive use of motions to reconsider and clarify. This is just stupid. Don't get an attorney who files motions to reconsider and motions to clarify. They're pointless, which substantially increased attorney hours and expenses without materially advancing the case, of course. They never would. More telling, the court found that the huge, almost impossible hours recorded during the trial months appear to be an attempt to gain an understanding of evidence and facts that should have been mastered months earlier. In short, the court's extensive factual finding paint a picture of a litigation strategy that was inefficient, ineffective, and unjustifiably costly. So, boy, this is why I love this opinion, because it's so rare that you see a court that actually comes out and really calls it like it is. This attorney for Ms. Dahl was inefficient, ineffective, and unjustifiably costly. As we have previously discussed, Mr. Christensen failed to properly designate expert witnesses for Ms. Dahl and failed to submit expert reports in accordance with the requirements of Rule 26. As a result, her expert's testimony was substantially limited. The district court specifically noted that this failure to properly designate and disclose expert witnesses rendered their testimony inconsequential to the final determination of the case. Yet, Mr. Christensen requests an award covering these expert witnesses' substantial fees, totaling approximately $327,000. We agree with the district court that these claimed fees for experts who were never properly disclosed and were thus rendered useless to the litigation were unreasonable. Expert disclosure requirements, the deadline for those, you must meet those. You can't just blow them off. They're extremely important. If you miss an expert disclosure deadline, the court's probably going to not allow you to present that expert testimony, which is what happened here. But then at the same time, Mr. Christensen wanted to be awarded the fees related to these experts, even though he didn't disclose them in a timely manner. All right. The district court rejected this fee arrangement as an improper contingency fee in which Mr. Christensen created by contract a mechanism to seize as much as the entire proceeds awarded to his client from the estate to pay the bill when a recovery was achieved. In declaring the fee agreement to be prohibited, the court relied primarily on Rule 1.5d1 of our Rules of Professional Conduct, which prohibits attorneys from entering into an arrangement for any fee in a domestic relations matter, the payment or amount of which is contingent upon the securing of a divorce or upon the amount of alimony or support property settlement in lieu thereof. The court observed that Mr. Christensen had made no attempt to collect any of his fees and instead simply allowed the fees and costs to accumulate with substantial interest. It reasoned that the only logical conclusion was that Mr. Christensen's payment had always depended upon a recovery in favor of Mrs. Dahl. Okay, you can't have contingency fees in divorce cases or any other kind of domestic relations matter unless it's for collection of a child support or alimony judgment. But here, what the court found was that Mr. Christensen's ability to recover his fees was contingent upon Ms. Dahl actually prevailing in this case. Mr. Christensen said no, it was always going to be due no matter what, but the court disagreed. And the Utah Supreme Court ended up actually upholding this finding that this was a prohibited fee agreement because it effectively amounted to a contingency fee agreement. Now, the interesting thing here is that, let's see, I have one more part here. Yes. So this is talking about just how much the firm billed for this case. For 2009, the firm billed 2,981 hours through the end of October. Although the court acknowledged that preparation for trial can require significant hours, it found that the huge, almost impossible hours recorded during the trial months appear to be an attempt to gain an understanding of evidence and facts that should have been mastered months earlier. The district court also questioned Mr. Christensen's claim for hundreds of hours spent on review of the case file, finding that the time attributed to that activity in his case was grossly inappropriate. Moreover, the district court found that the strategy employed by Mr. Christensen was wholly ineffective at producing favorable results for Mrs. Dahl. For example, Mr. Christensen failed to provide competent evidence as to Ms. Dahl's financial need for alimony or an attorney fee award by not doing the financial declaration. As a result of this deliberate and ill-conceived choice, Ms. Dahl received neither temporary nor permanent alimony, and the district court declined to award her any attorney fees. Mr. Christensen also employed a litigation tactic involving aggressive use of motions to reconsider and clarify. So be careful with the attorney that you choose. He or she could be leading you down a bad path. It can backfire to be too aggressive when you're using motions to reconsider and motions to clarify or any other type of motions that really are not warranted and would be considered unreasonable if you're making a claim for attorney fees. We agree with the district court that these tactics delayed the proceedings and served only to increase the fees charged to Mrs. Dahl. Wow. So that just goes to reasonableness. Clearly not reasonable. Finally, we are extremely troubled by Mr. Christensen's handling of the pretrial disclosure process. He failed to properly disclose the exhibits he intended to offer at trial. The district court excluded most of Mrs. Dahl's trial exhibits, and the court correctly refused to allow experts' testimony, which further prejudiced Ms. Dahl. So this is just calling out Mr. Christensen for being unprepared, inefficient, just not being a very good attorney for this case. In short, for all the thousands of hours billed by Mr. Christensen in the course of this litigation and his more than $2.1 million bill, the results he obtained from Ms. Dahl could only be characterized as extremely disappointing from her standpoint. When an attorney consistently fails to perform basic skills in a competent manner and the client is harmed as a result, we will not allow that attorney to collect patently unreasonable fees. This is one thing that I know that our firm really focuses on is we want to do things that create value. You have to do a certain amount of work to make sure that you're producing quality, but you don't want to overdo it because that's not going to do the client any good, and it could end up really not giving you a good return on your money. You always want to make sure with an attorney that you're getting a good return on your money. Further, we invalidate Mr. Christensen's fee agreement with Ms. Dahl on the grounds that they violate Rules 1.5 and 1.8 in our Rules of Professional Conduct and refer Mr. Christensen to the Office of Professional Conduct for disciplinary proceedings arising from these rule violations. Okay, there you have it. That's the case of Dahl v. Dahl. That's what the court is going to consider when considering the reasonableness of the fee. Make sure you do those financial declarations and make sure that your attorney isn't overbilling you in the hopes that he can overbill the other party, because the truth is that's probably not going to work. That's going to be found to be unreasonable. If you have a question about whether you can be awarded attorney fees in your divorce case, you can give us a call, 801-312-9330, 801-312-9330, Fontenot Spevak. We serve Salt Lake County, Davis County, and Weber County.